Our next case is Pegasus Wind versus Tuscola County. This is also a 15-minute mini oral argument on the application. Good morning. You both have 2 minutes of a free fire zone, and you may reserve time for rebuttal, but we ask that you keep track of your own time. And please begin whenever you are ready.
Good morning. May it please the court, my name is Mike Homier, and I represent the Tuscola Area Airport Zoning Board of Appeals intervening appellant. I'd like to reserve 2 minutes of my time for rebuttal. And with that, I can start by saying that this is a curious opinion by the Court of Appeals on a land use and zoning issue. It's not often that you get to address the Airport Zoning Act, which was adopted in the 50s, sometimes not really amended since then. But this has to do with variances. And I'm going to focus my time on the questions that the court has asked, which are good ones, but which I think are easily resolved. And that's because for some 50 years, in fact older than I am, the case law has been to link both practical difficulty and unnecessary hardship in the case of dimensional and use variances to conditions inherent or unique to the property at issue. If the Court of Appeals decision were to be left standing, it would throw all of that case law into disarray. And that's because zoning boards of appeals have to focus generally on property and not people. We don't necessarily care in the zoning context who owns the property, rather what are the uses of the property and what variances need to be requested pursuant to those. So the Court of Appeals decision is baffling given the case law both pre-Zoning Enabling Act, which is 2006, as well as post-MZEA. So starting with those cases that we set forth in our argument, or in our brief, like Puritan, and ending with this court's decision in Johnson v. Robinson, it was clear that there was a direct link to the use of the property as a basis for justifying relief, whether it be a dimensional or a use variance, where a dimensional variance is dealing with size and bulk and setback. Those issues are still related to the condition of the property. So if we disassociate...
Counsel, for non-use variances, I mean, I've tried to think of examples, and I'm confident you can give them to me. Isn't it true that in the case of most non-use variances, the conditions of the land itself isn't really the issue? It's more, is it too tall or is it too wide? It's less about, is there something that has to be carved out of the land to allow for the variance?
Sometimes, although I would say we deal with this a lot in setback cases, right? So the property does not lend itself to complete use of that property, and so in order to get some use out of the property, you might have to slide a building closer to the setback. Or what happens a lot, honestly, is somebody builds it, they didn't stake it right, and now they want a variance. And so in that case then, and we'll get into the self-created hardship, that's where these things come into play. But there are topographic or exceptional features of properties that do lend themselves then to granting those dimensional variances. But in all of those instances, they are still tied to that characteristic of the land. If we don't do that, and what the Court of Appeals really did here was they said, no, this is going to be considered a plight of the owner versus a focus on the land. And so if you take that to the extreme, and you know, I represent a lot of municipalities. I go to a lot of zoning board of appeals meetings. I look at a lot of ordinances dealing with this. And for the most part, they are all tied to that condition of the land, because if you don't do that, what happens is somebody comes in and they say, you know, I know your ordinance says it's 1,000 square foot pole barn, but I need 3,000 feet. Well, why do you need 3,000 feet? Because I want it, right? Because I want it, I have a lot of stuff, and now I have to pay to have that stuff stored somewhere else. You can see all of a sudden this turns into a practical difficulty. If we focus on just that, you're going to be hard-pressed to then say, I'm sorry, you don't qualify. Tie it to the land and tell me why it's necessary. And that's really where the Court of Appeals got it wrong here.
Oh, okay, so I want to just pivot for a minute. I am so sorry to detour like this. I'm going to ask Sister Council the same question. This is I find the Airport Zoning Act, which has been a fun couple days going down that rabbit hole. It's very unique because it's kind of an overlay, right? You have zoning for rural land use. You have obviously, you know, Pegasus that did all the work to get their, you know, permits and leases and all the things they had to do to get special permission to put these up with the existing zoning. And then you have this overlay that goes on top of it. Has anybody litigated these cases under the Airport Zoning Act as use variances? Are they always non-use when we're talking about the Airport Zoning Act? Is that how it's understood? It wasn't raised by any party, so I'm assuming, including amicus, so I'm assuming it's just understood everything under airport zoning is always non-use. And that was one thing I had a question about.
Yeah, and I think generally that's right, particularly since the amendments to, as you know, the Zoning Enabling Act consolidated the prior Zoning Enabling Acts, because we had a City and Village Zoning Enabling Act, a county and township. They all consolidated into one in 2006. When they did that, they severely restricted the ability of certain entities to issue use variances, okay, under the Zoning Enabling Act. So, for example, townships, if they did not issue them before, I think, February of that year, could no longer issue use variances. The same is true, and I think this is briefed in both parties' brief, where the ability to issue use variances is restricted under the Zoning Enabling Act, which is why you don't then have them now under the Airport Zoning Act. I can't tell you that they were ever not issued under the Airport Zoning Act, but it's true that it's an overlay, and the zoning then would be sort of that underlying that, and you can't issue something that's in conflict with the Zoning Enabling Act or with the township zoning, because that's where most of these cases are.
Yeah, I was just trying to think if there's an example with the Airport Zoning Act where it's actually, you know, a party comes asking for a variance and Airport Zoning Board says, sorry, that's a use variance. We can't do anything about that. We have no authority. You're out of luck. I was just trying to think if there's an example like that, and maybe it is, they're just all non-use variances.
Yeah, and I suspect that, you know, when you look at the Airport Zoning Act, which sets forth a standard for both practical difficulty and unnecessary hardship. The unnecessary hardship was codified, right, in the 2006 Zoning Enabling Act, but it codified what everybody knew to be true, that there were two different variances that would be issued. One is the dimensional, two is the use variance, and the use variance went along with the unnecessary hardship or unnecessary burden. And so under the Airport Zoning Act, because it was issued in the 50s, it just never caught up with the codification of the 2006 Zoning Enabling Act. However, the Zoning Enabling Act is still applicable, so it didn't matter that it wasn't revised, to say no use variances under the Airport Zoning Act either, because they're covered under the Zoning Enabling Act. Does that make some sense?
Thank you, yeah.
Okay. It's an important point, too, and I don't want to blur all of the questions together, but it's an important point because what we keep focusing on, what the Court of Appeals focused on, was the landowner. Always, right? Pegasus this, Pegasus that. Pegasus entered into these leases. Pegasus entered into these power purchase agreements. But let's say, for example, you take Pegasus out of this. Let's assume that it's the agricultural property owner who now is proposing this same use. I don't think there'd be any question he would not be entitled to a variance for that same use. Why? Because the underlying property use still exists. That is, you can deny that variance because it's not tied to a condition of the property that prevents or that constitutes an unreasonable use of the underlying agricultural property. So, for instance, the Court of Appeals says, well, this is the sole place in all of the world where you can locate wind turbines. So that's simply not true. Drive up into the Thumb. There are lots of places in the Thumb where this comes together. This happens to be problematic because it's in the airport zone. And the airport zone is a special place, right? The FAA regulates it, MDOT, Bureau of Aeronautics regulates all of those tall structures, and for good reasons. So, for instance, if a property owner came and said, and I'll use this simply as a hypothetical, let's say, these towers are 500 feet tall. Well, the property owner there now out in the country wants to put a 500-foot tall office building. That variance would never get granted. Not for height, not for use, because the underlying property is not at issue. That is, you can use the underlying property for the stated purpose in the district, that being agricultural uses.
Council, I just have a quick question.
Sure.
There are 30 windmills currently present, right?
33.
33, okay. And we're talking about the addition of 8 windmills, correct?
Correct.
Okay. And, and I understand, the issues that go into that. But what is the main concern or the real issue here as it pertains to the 8? You have 33, and what role will these 8 ultimately do in terms of the impact?
So it's a good question, Justice Bernstein, because this gets into sort of the evidentiary standard, where the evidentiary standard was competent material substantial evidence, right? And the Court of Appeals, in our view, improperly went back and weighed that evidence improperly. The ZBA held 6 hours of hearing. They took testimony from an American Airlines pilot, a former pilot for Dow Chemical. These are people that use the airport every day, and what you'll see is a common theme. They're very concerned about the safety, particularly in those conditions that may be an emergent condition where somebody takes off, has an emergency, and now they are flying in between these turbines because they are in close proximity to the airport. And, the Court of Appeals said at the end of the day that no reasonable person could support or would support the decision made by the Zoning Board of Appeals based on that evidence. Except Judge Murray, who dissented, who found it reasonable. So I think by definition it's almost improbable to say no reasonable person could decide a different alternative based on the same evidence. And the courts in this state have for many, many years said the courts should not act as a super zoning board because that's not the role. The role is to give due deference to the ZBA. They had 6 hours of hearings, tons of witnesses who were associated both with Pegasus and with using the airport. They weighed that determination, they made findings of fact, and under the Airport Zoning Act, those findings are conclusive. And it just was improper for the Court of Appeals to invade that. So with that, unless there are any questions, I'll save my rebuttal time. Thank you.
Good morning, or I guess afternoon at this point, Your Honors. Ashley Chrysler on behalf of Appellee Pegasus Wind. This court should not grant leave or reverse the Court of Appeals holding in this case. The Court of Appeals published this case, and you heard Brother Counsel say this as well, because it presented an issue of first impression under the Airport Zoning Act. And this is the only case in the 73 years that, since that statute has been adopted, that's come before any appellate court. This case also is a unique, highly complex case that's unlikely to be representative of cases in future zoning disputes. And the Court of Appeals in this case reached the right result. Now, the Brother Counsel in the AZBA focuses primarily on prior case law and how if we adopt the opinion of the Court of Appeals here, it's going to upend decades of prior case law. But what's really missing from the argument in their briefing and here on appeal as well before the court is the practical realities or necessity of the holding that they're advocating for, particularly as it relates to the unique circumstances and whether those have to be inherent to the land to establish a practical difficulty for a non-use variance. As we know, when we're looking at this statutory term, we have to try to give intent. We have to give effect to the intent of the legislature, and this court should not incorporate an extra statutory requirement like the one that the AZBA is advocating for just because we don't see a reason not to do that. There has to be a reason to incorporate the uniqueness requirement into the practical difficulty standard, and there is not a reason to do so in this case. In fact, doing so would improperly read an artificial limitation into the statute that has no basis in the text, and that would unnecessarily elevate the practical difficulty standard to a point where certain uses, like these large-scale renewable energy projects, simply would not be allowed.
So, counsel, I agree that language is not specifically in the statute, but we obviously have a long history. And Johnson said, hey, we apply this to both use and non-use variances. What are we supposed to do with that? Do we say, oh, airport zones are different? It is a different statute, so we interpret it different for airport zoning? Is that what we do?
No, Your Honor, I think under either the Airport Zoning Act or the Zoning Enabling Act, it can be interpreted the same way so that unique circumstances inherent in the land are not required for practical difficulties.
So you would say that does reach all zoning then?
That's
obviously
correct.
that's what the concern that amicus has raised, that we've got this sort of flood of undoing lots of decisions that have been made because inherent in the land has been considered.
Yeah, I think it makes sense under either statute, Your Honor. I would disagree with the amicus and with Brother Counsel that this would upend decades of settled case law in this area. I don't believe that that's how cases have interpreted the practical difficulty standard throughout the decades.
Although he gave a good example of the farmer next door who, take away windmills and just is it a rural land use or not? And then he gave the example of examining the land and why that variance, the airport board would say, nope, sorry. So that seems like a pretty realistic hypo of how it would work in effect for all of their zoning.
So I have two issues with the example that Brother Counsel used there. First, really what he was focusing on when he's talking about, well, the reason they can deny that is because there is an agricultural use of the land. That's actually the unnecessary hardship standard. That's not the practical difficulty standard. You don't have to show to obtain a non-use variance that there's no reasonable use of the land. That's the unnecessary hardship standard. So that's the first problem. The second problem is he used an example also of somebody coming in and saying, we want this variance. There's nothing that's really tied to the land. It's not unique to the land, but I want it. So now the Zoning Board of Appeals has to grant it. That's also not true because they still have to meet the practical difficulty standard. And a practical difficulty doesn't mean I want it. And that's not how any court has ever interpreted it. So there are still guardrails in place, even if that unique circumstances requirement is not read into a non-use variance requirement. That's something that all courts have looked at, what the practical difficulty standard requires. As this court knows, there really isn't a particular standard, but there are factors that courts look at to determine whether a practical difficulty has been met. And under none of those factors can somebody just simply come in and say, well, I want a variance and therefore I'm entitled to it.
Counsel, my concern is with the safety, and I realize you have 33, as I was talking about with Brother Counsel, and I realize that you're asking for 8, but there is testimony from pilots that say that this could cause an issue. If you have bad weather, it could cause an issue, as Brother Counsel indicated, if you have a blown engine on takeoff or a visual problem on landing. And I guess my question is, you have your 33. If you add the 8, it seems to be that the pilots are saying that they have some real concerns over safety. Can you address that? I mean, the notion of having to fly through these windmills, especially if you have a mechanical problem and it's being so close to the airport, and then you have the different issues of classification as it pertains to kind of visualization. What's your response to that? The Court of Appeals seem to just kind of overlook that, and I'd like to hear from you as it pertains to the safety.
Absolutely, Your Honor. I think, and I don't think the Court of Appeals necessarily overlooked it. One thing I'll correct is there are 52 turbines that are actually operating in this area. It's not just 33. There's 52 in this project. There were actually turbines that were existing in this area before that as well. So there's more than just that in this area. And the reason I bring that up is because I think it lends itself to explaining why there isn't a safety concern with these particular 8 turbines. Because there are already so many, and there's a picture that the Court of Appeals used in its opinion that we also used in our briefing below and before this court. And that picture really is worth 1,000 words because it shows there are already a number of structures in the area where these 8 turbines would be placed. They're going to be interspersed with these other existing structures. And so what pilots are having to do already without these 8 turbines there is they're having to circumnavigate those structures to avoid any potential safety risk. So what the Court of Appeals did with that, and rightly so, we believe, is they said adding these 8 turbines is not going to create a safety risk that isn't already in existence. And we know that these turbines have been operating already without any safety concerns. So the Court of Appeals really looked at whether these 8 turbines and whether what was presented before the Zoning Board of Appeals added some type of a safety risk that wasn't already there. And the answer to that is simply no. And nobody has ever made an argument. There's nothing in the record that says these 8 turbines are going to cause an issue. So that's really why there's no concern about the safety risk here, Justice Bernstein. And our expert, Capital Airspace, Ben Doyle, spoke on our behalf at the ZBA hearing, went into a lot of detail about why there is no additional safety risk because of these 8 turbines.
Thank you, Counsel.
So, Your Honors, getting back to the practical difficulty standard, one thing I want to emphasize here is the reason that it doesn't make sense, or there's no reason to import a uniqueness requirement for non-use variances, is if you look at the difference between a use variance and a non-use variance, what the goals they're trying to accomplish and what they're actually allowing, there is a reason that you would need to have a uniqueness requirement for use variances. There is not a reason to have that uniqueness requirement for non-use variances. And that's because a use variance, and everybody acknowledges, all the amicus acknowledge, and the AZBA also acknowledges, that use variances have a higher standard because they are actually changing the use of the property. It's akin to a rezoning or an ordinance amendment without any input from a legislative body. So when you're changing the use of the land, as I mentioned earlier, you have to show that the property cannot be used in a manner that's consistent with existing zoning. So there's no scenario where property can't be used as zoned for reasons other than something that's inherent in the property itself. And that is simply not always going to be true when you're talking about a non-use variance. Non-use variances are essentially anything other than a use variance. And there's going to be a number of different standards. We've cited some examples in our brief where a non-use variance doesn't have any logical connection to the unique circumstances of the property. There are going to be circumstances where it does, and Brother Counsel mentioned a couple of those, but in a lot of cases, there is not going to be that direct connection. So it simply doesn't make sense to incorporate that requirement into the non-use variance standard. And we think the Court of Appeals got that right when they issued their opinion. So unless this court has any other questions, I think we'll rest on our briefs with that. Thank you.
Thank you.
Just a couple of things. So we kind of laid out in our brief, beginning with the Tyerman Joy 1960 decision, Puritan Greenfield in 1967, Badanek in 1970, George versus Harrison Township, 1973, this court's decision, Johnson, Robinson Township, 1984, Davenport, City of Grosse Pointe Farms, and Jacques v. Department of Environmental Quality. All of that case law is unbroken for the simple proposition that both use and dimensional variances have to be unique to the property itself. That is unchallenged here, and curiously enough, and I don't know why, the Court of Appeals never even mentions Robinson. It is this court's case. It is directly on point, saying we see no reason not to apply the same standard, both to dimensional and use variances. I don't think it could, from a practitioner's point of view, we deal with this all the time. Everybody knew in 2006 what was already true, and that was just codifying the existing law at the time, creating these two standards for two different requests for variances. With regard to the safety aspect, and Justice Bernstein talked about adding 8 turbines, the Court of Appeals, I think, took the opinion or had the opinion that, well, because nobody's crashed into one yet, it must be safe. But that's really not what we should be looking at. In fact, that's not what the AZBA looked at. And the problem with the Court of Appeals then is they took that same evidence and weighed it differently and construed it differently and reached a different opinion. I see my time is up. I thank you for your time. If you have any questions, happy to answer them.
I don't see any. Thank you both. The case will be submitted. And
Thank you.
The court will stand at recess until 12:45.
Oh, great.